The offences were triable by the Court of Session. Accused person cooperated in the investigation. Police released them after giving 41A notice and summons patra to remain present before the Court of Judicial Magistrate First Class at the time of filing of charge sheet. That means production of accused along with charge sheet. Charge sheet was filed before the Judicial Magistrate First Class and the offences are triable by the Court of Session. Now the Judicial Magistrate First Class cannot give bail to those accused person. Now in these circumstances, so why such circumstances or scenario arise? Importantly, let's understand which court at which stage will adjudicate the matter. See the Schedule 1, Column 6, by what court triable. It's pretty clear, it is absolutely clear about the trial. But when it comes to pre-trial, there is confusion. In offences under IPC, BNS, Arms Act and any other act, whenever any accused person will be get arrested, irrespective of it is triable by which court, that accused person will be produced before the concerned Judicial Magistrate First Class under Section 167 of CRPC and 187 of BNSS. Second, but in acts such as POCSO, MCOCA, Prevention of Atrocities and MSCB and other acts, whenever there is provision of designation of special court, the accused person, the arrested person will be produced before the Sessions Court, which is the special court having jurisdiction or having charge of that act. Now a twist. Third type is Section 36A, subsection B and C of the NDPS Act. Whenever the accused person will be arrested by police, police will produce that accused person before Judicial Magistrate First Class. During period of police custodial remand, that person will be produced before the JMFC Court, and whenever the Judicial Magistrate First Class thinks fit to forward him in magistrate custody or judicial custody, both are same, in judicial custody, that time the Judicial Magistrate First Class will forward that accused person in custody of Sessions Court, which is the special court, which is NDPS Special Court. The term PCR, police custodial remand, and the term MCR, magisterial custodial remand, both are commonly used. Why I am using the term judicial custody? Because whenever the accused person is in custody of a Sessions Court, the special court empowered under the Special Act, at that time the presiding officer of the Sessions Court most commonly generally use the term judicial custody. Now it is depending upon presiding officer. Part of remand is clear. Now let's see regular bail and furnishing of bail. First of all, understand the term having custody of. That means the accused person, the arrested person is in custody of dash court, the JMFC Court or the Sessions Court, the special court. Having custody of. There are three aspects. First, all the offences are triable by Court of Magistrate. It is obvious that the first regular bail application will be filed before the Magistrate Court, Judicial Magistrate First Class. Then the bail will be furnished before the same court, JMFC Court only. Second aspect is that one or all offences are triable by Court of Session. In that circumstances, the first regular bail application will be filed before the Court of Session. After getting it allowed, the operative order, the bail will be furnished before the Court of Magistrate, because the accused person is in custody of that Judicial Magistrate First Class. Third aspect is offences under POCSO, MCOCA or MSCB or Prevention of Atrocities Act. In that circumstances, the bail application will be filed before the special court, the Sessions Court, and then the bail will be furnished before the same court, as that accused person, the arrested person, is in custody of that court only. Similarly, whenever the Honorable High Court or Supreme Court passes any order for release of any accused person, arrested person from the custody, depending upon which court is having custody of that accused person, bail to be furnished before that JMFC Court or Sessions Court. Now a rare and tricky situation. FR was lodged under Section 353(3) of IPC. In that FR, and therefore was having apprehension of arrest. He filed for an anticipatory bail. Anticipatory bail was granted, and thereafter he cooperated in the investigation. In further due course of investigation, police traced out, identified other two offenders, Other two offenders cooperated in the investigation. 41A notice was served to them, and thereafter a summons patra was served to them to remain present before the concerned JMFC court at the time of filing of charge sheet. That means at the time of production of accused along with charge sheet. See, production of accused along with charge sheet means producing the accused at the time of filing of charge sheet. At that time, in order to secure the presence of that person, the accused person, court will take him in custody. And if there is no need to take that accused person in custody, court will release that person on bail. Now in these circumstances, section 353 of IPC in Maharashtra, as per amendment, it is triable by court of sessions. Charge sheet is being filed before the court of judicial magistrate first class. Offence is triable by sessions. JMFC court cannot grant bail in that offence. Thereafter, even it was not required, the accused person has to go in custody, and thereafter the sessions court will grant him regular bail. To avoid that 2, 3, 4, 5 days custody, we filed an anticipatory bail application before court of session after filing of charge sheet. When his arrest was not necessary, we explained all the circumstances before the court of session and secured bail. And after obtaining that operative order to release that accused person in the event of arrest, we furnished his bail before the court of judicial magistrate first class. There are technical aspects. Judicial magistrate first class, sessions court, one procedure in one court, the other procedure in another court. That's why this is a maze, this is a wave, this is what we can say, whatever it is.